So Mireille Hildebrandt is a professor of smart environments, data protection, and the rule of law at the science faculty of Radboud University in Nijmegen. She has been teaching law to master students of computer science for 8 years and recently published the first comprehensive textbook, Law for Computer Scientists and Other Folk, with Oxford University Press, in open access. If I'm not mistaken, you have put this book on the drive where people have access, where they have posted their videos. You have put some documents there. She's a lawyer and a philosopher. Her main affiliation is with the law faculty at Free University Brussels, where she is co-director of the research group Law, Science, Technology and Society Studies. She was awarded an ERC Advanced Grant for counting as a human being in an era of computational law, starting in 2019 up to 2024, leading a team of lawyers and a team of computer scientists on the subject matter of legal technologies. It's a great pleasure and honor to have you on board, and I give you the floor, of course. Thank you very much.
Well, thank you very much. Thank you very much for having me. I'm sure that this presentation is going to be very different from some of the other presentations. I hope you will bear with me. And to start, I'm basically starting at the end because the starting time is actually the end time that was predicted. But since we're human beings, we're very unpredictable. Maybe that's already a lesson. And I understand all the other presenters, they end with a perspective on the workshop. Alas, I cannot stay for the rest of the workshop, but two of my PhD students are going to be there. That's Arnaud de Bois, he's there now, and Lisa Janssen. She's with TNO. I think she will be there the other days. Because I hope that some of the things I say trigger, how should I articulate this, trigger a first sense of what legal protection by design for robust AI could be. So on the right side, you see the cover of the textbook. The textbook is indeed on the drive, so would strongly invite you to have a good look at it. It's meant to be a textbook for computer scientists. I taught for 8 years, and I'm very aware that computer scientists are not always so much in for text, certainly not beginning a book at the beginning and then ending at the end. So it's also designed, the book, to confront you with text, but to allow you to cherry pick a bit and to link between different parts. I want to very quickly say something about what I think is robust AI, how I understand it, and what is legal protection by design. I want to distinguish the development phase of a technology and the use context, potential use contexts. I want to distinguish between fundamental rights concerns and safety concerns. I have chosen to move a bit deeper into the fundamental rights context, mainly because the safety concerns, especially the whole upcoming liability framework of the European Commission, much is still unclear. So I'm going to discuss with you legal protection by design in terms of fundamental rights and the GDPR, then moving to what that means for designing this into artificial intelligence, architecture, systems, applications. And I hope you will get a first inkling of what that would mean for liability issues, so for private law liability. Let's first look at robust AI. I read robust. I've seen the previous presentations where quite a lot of terms like resilience, it was this wonderful series of terms, which I can't find now, but I see a lot of terms that are terms of the trade, probably used differently in computer science and outside computer science, and maybe they are still being tested and used differently also within computer science and by different developers. How I read the term robust is that it's about reliable, trustworthy, and safe systems. I have used also the term responsible. As we all know, the European Commission is very concerned about the idea of responsible AI. I'm also part of the Humane AI network, where, for instance, Virginia Dickman is working. And the idea of responsible goes beyond reliable, because it also looks at whether the people who are going to suffer the consequences or enjoy the consequences of certain applications and architectures, how these systems are going to interact with them, which is fundamentally unpredictable, but it is very important nevertheless to anticipate that and to engage in a conversation with these people. So there are different ways of achieving such robustness: verification, formal testing, data-driven, but maybe the most important in the end is, and I don't think that's an alternative, I think we need all three, is validation, and that's about IRL in real life. So I'm distinguishing between data-driven and real life, because data is not the same as real life. How do I understand AI? I'm of course not going into the libraries that have now been written full of definitions. I don't think they're always that interesting. I'm focusing on data and code-driven computing systems, noting that all data-driven systems in the sense of machine learning are also code-driven. And I'm, of course, as a lawyer, particularly interested in the moment that these systems are taking certain decisions or conglomerates of decisions, and what are the consequences for the end users. AI is often called a research domain. Some people call certain types of architectures artificial intelligence, or even the applications themselves. Let's look at the next term, legal protection by design. So legal protection refers to an architecture, system, or application being under the rule of law. That means playing out within the contours decided by a democratic legislator, containing technical and organizational safeguards against human rights violations. And very importantly, decisions and or implications of those systems must be contestable in a court of law. By design refers to the level of the research design stage. So when exploring, or at the later stage, confirming, for instance, if you're talking about machine learning, a trained model, but also first the learning algorithm, so that development stage. But it also refers to the code that comes out of that, the architecture that is built as a result of all that exploration, the system that is put out in the world as a specific application or set of applications. And of course, the last point is these systems always have different settings, and protection by design can also refer to what sort of settings you can choose. So that's very important. What are the operators of the systems, the providers of a certain service that are using the system? To what extent can the end users change the settings, and what does that mean for their agency, let's say? From a perspective of the law, it's very important to make a difference between the development phase and the use context. For instance, in the GDPR, General Data Protection Regulation, there is a rather large research exception, which doesn't mean that the GDPR no longer applies, but it means that some of its constraints are relaxed. And when you look at private law liability, tort law, having to pay compensation for damage, being liable to an injunction to stop using a certain system, for instance, that's all part of private law liability. Usually that applies to the party that puts a certain product on the market, or the operator of a system, the provider of a certain service. And you could say that when you think in terms of these safety critical applications or infrastructure, that could be the airline that has bought a certain plane or a certain traffic coordination system, and that is offering services, selling tickets, etc. So one of the very important thing is that, and I think you're all very well aware of that, that it is crucial in the development phase to foresee the legal regime that applies in the moment that these systems or products or services go out into the real world. So certain things are allowed when you are developing something. I'm now actually particularly thinking of the GDPR. So processing of personal data in a research context might be allowed, while for that same system, when it's out in the market and people are actually using it, the research exception might not apply, but it's very important still to foresee that. So as I said, it's important to see when you look at the European Commission's white papers and other papers that they published in February of the last year on AI, the position that they took there, for instance, on European data space. So the idea that it's very important that Europe develops artificial intelligence architecture, systems, applications for which it is important that the industry shares data as much as possible, that public administration shares data as much as possible. And the Commission goes further than, for instance, the Open Data Directive, which excluded personal data. The Commission now explicitly says it's important that also personal data, as much as possible, is going to be shared. And that, of course, has many consequences. So that means that apart from the existing legislation, the European Commission is considering a set of options to look at the impact that the use of artificial intelligence within the European Union might have, and how to deal with that in terms of perhaps also new legislation. So it's interesting and important to see that the European Commission seems to take a risk approach here. That basically means that whoever is developing these systems, but also whoever buys them and then uses them as products, services, etc., will have to anticipate what sort of risks are created. And that seems to be taken from the GDPR, that speaks in various articles of the risks for fundamental rights and freedoms of natural persons. This basically requires a precautionary approach. So the term risk can easily be misunderstood. What you see when you read the legislation, when you understand the kind of decisions that courts take, when you look at the GDPR, then basically it's asking developers and users, in the sense of service providers, etc., to take a precautionary approach, to do more research, to be more certain of the robustness of these systems. When you look at the policy documents at this moment about private law liability, then it seems to be that there will be, or there may be, strict liability, or there is at least a move towards strict liability for whoever takes high risks for safety. And of course, in certain circumstances, like when you're thinking of aircrafts, their unsafety is by definition a high risk, because the threats, even if the chance is very small that something happens, the threats, the actual damage and harm that is done will probably be very high. So there is a move on the side of private law liability towards strict liability. That basically means that if the victim can prove damage, and if you think, for instance, of the Product Liability Directive, once that is updated, that might mean that if they can prove, so if the victims can prove damage and a defect, then the causality is assumed. Either that can mean two things. It can mean that the entity that is held accountable, that is sued as being liable, so for instance an airline, cannot disprove causality. Once the damage is proven and a defect is proven, they will have to pay, or they could prove that there was no causality, which is, as everybody knows, in these circumstances, probably next to impossible. Okay, I'm going to move from there to the fundamental rights protection. And it's important to see that in Europe there are two overlapping regimes of fundamental rights. There is the Council of Europe. 47 states, Russia and Turkey, are part of that, falls under international law. And there is the European Union, 27 states that are all a member of the Council of Europe. The Council of Europe has a treaty, the European Convention of Human Rights, with a court in Strasbourg. The European Union has since 2009 the now binding Charter of Fundamental Rights of the European Union, and the highest court of the Union is the court in Luxembourg. In the European Convention, there is, for instance, the right to privacy, to non-discrimination, in the protection of rights. Please note the right to privacy is both more and less than the right to data protection, but there are many more rights, like the right to a fair trial, freedom of speech, associations, etc. There is also a specific convention within the Council of Europe, so this larger jurisdiction of 47 states, that is particularly directed to the protection of individuals with regard to automated processing of personal data. This convention has been updated recently and has more specific attention to automated decision systems, which is going to be very relevant for all AI applications. The Charter of Fundamental Rights of the European Union has the rights to data protection and privacy, Article 8 and 7. Note that the fundamental right to data protection, in a sense, is a new right. As far as I know, there is no other international human rights body or treaty that speaks of that as a separate right. Privacy and data protection are overlapping. There are also in the Charter the rights to non-discrimination, freedom of speech and association, presumption of innocence, fair trial, and the right to conduct a business. If any of the rights of the Charter, so that's these fundamental rights of the European Union, overlap with human rights of the European Convention of the larger jurisdiction, then the protection offered by the Charter of Fundamental Rights can never be less. It can be more but that basically means that a court in Luxembourg has to look very well at the protection decided by the court in Strasbourg. Now let's move from here to the GDPR. The GDPR is, one could say, retroactively a kind of elaboration of the fundamental right to data protection. The GDPR uses a very broad notion of processing, so any manipulation, including storage of digital data, falls within the scope of processing, and even other systems that are not digital. But let's now stick here to the digital. It also has a very broad notion of personal data. That's why it's going to be very relevant also for many of the safety critical applications that you will be speaking about this week. Processing operations on personal data must always have a legal basis. So if one is dealing with the processing of personal data, for instance, behavioral data, for instance, of a passenger, of a pedestrian, or of a driver, because at this moment there are still drivers in the car. The same goes for planes, passengers, personnel, cabin crew, etc. Pilots, of course. They are, and any behavioral data you are using fall within the scope of the GDPR. So they must have a legal basis. Many people think that's always about consent. That's a very American idea. Under the GDPR, consent is just one ground. It's not a very strong ground. Why? Because you must make it as easy to withdraw consent as to give it. Yeah, and that already shows that it's quite a vulnerable ground. But there are a lot of other grounds that make a lot of sense. Like if you have a contract and it's necessary to exchange your personal data, then that's the legal basis. If you're dying and you're not conscious, then all sorts of data can be processed without your consent. If there's a legal obligation, of course, you don't also have to give consent. If we're talking about a public task or public authority, think of the military, think of disaster management, then that is a legal ground. And then the last legal ground is the legitimate interest of the controller. The controller is whoever decides the purpose of the processing. So if that controller has a legitimate interest, then they can use that as a legal basis. That ground is a little bit complicated, but let's not go into that now. On top of the legal basis, the controller, so whoever determines the purpose, whoever is in charge, has to comply with the legal principles. Principles sounds maybe a bit vague, but they're simply, this is simply in this case another term for rules, quite foundational rules: transparency, lawfulness, fairness, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. And part of that accountability is also private law liability. The data controller, as I said, is defined as whoever de facto determines the purposes and the means, but the means can be subcontracted as long as it's clear that whatever means is used by the subcontractor is under the responsibility of the data controller. And the data processor is defined as whoever processes on behalf of controller. I can imagine that in many of the safety critical applications, architecture systems that you will be discussing, once these systems are integrated into products that are going to the market, or maybe it's infrastructure, maybe it's something that governments work with, that there will be many different controllers, often, sometimes joint controllers that together decide something. And that there will be many processors. What is to be remembered is if somebody is only processing personal data on behalf of a controller, but is then beginning to use those data for their own profit, for instance, then they are automatically, for the law, a controller and become liable for whatever they do. And it means the GDPR, all the requirements apply to them. There is a set of transparency rights and obligations in Article 12 to 15. I'm just going to cite to you Article 12 because it's very important. It says that the information given to people, end users, must be given in a concise, transparent, intelligible, and easily accessible form, must use clear and plain language, in particular when you're addressing a child, and it will be provided in writing or by other means, including where appropriate electronic means, but highlighted, concise, transparent, intelligible, easily accessible, using clear and plain language. That's an enormous challenge. And it's also enormously important for end users. In Article 35, the GDPR requires a data protection impact assessment. This is, again, very important because it's not personal data. But once you begin to apply that knowledge to target people for whatever reason, from that moment, that will, again, be personal data because it's then linked to somebody, you're targeting somebody. And basically, the data protection impact assessment requires you to foresee this. So to look beyond, okay, whose data are we processing? Did they give consent or is there another blah, blah, blah? No, you have to foresee if we deduce, infer certain, let's say, models, and we can apply these models to attribute different risk scales, different prices. There are all kinds of ways that you can target and profile people, then you have to foresee that if that may have a likely high risk for their rights and freedoms. Again, very important, also very important for this presentation, data protection by design and default. In case of risks to rights and freedom of natural persons, again, you have to sort of build in protection into the system already in the design phase. So it means that you anticipate, think of the data protection impact assessment, you anticipate, and then after that you say, okay, how can we resolve this? How can we reduce these risks? So you need to anticipate and then you mitigate. More importantly, it means you build protection, notably checks and balances into AI research and systems. So for me, robust systems mean systems that are not just verified and empirically tested, but and hopefully also validated, which, as I said in the beginning, is more than that. It means that you have engaged with the people who are going to be impacted. But also, when employed, it is very important that people have access to have sufficient transparency to see how they are being judged, etc. And how they can access what sort of verification, for instance, has taken place. Basically, the GDPR that benefit the effective enforcement of existing laws. So let's not be dependent on ethical inclinations of whoever, wherever. Let's look at what the law requires so that it can be enforced in the end. I'm going to skip that because I'm very aware that, So this piece of the presidency, very interesting. They talk about AI and different types of freedoms, AI and equality, citizens' rights and justice, like access to justice. They also refer to the work of the Fundamental Rights Agency, that's a European agency on AI. And let's very briefly look at the report that this agency published on the 14th of December, Getting the Future Right, AI and Fundamental Rights. Here you see a sum up of fundamental rights that are at stake. It's sometimes very irritating that everybody thinks it's always about privacy. Of course, we are all aware that this is very often about equality and non-discrimination and access to justice. But there are many different and other rights that are at stake. The most important thing that the Fundamental Rights Agency suggested here, proposed, is to make compulsory a fundamental rights impact assessment whenever that is at stake, saying prior to public procurement, during development, at regular milestones, and throughout their context-specific deployment in order to identify the risks of rights adverse outcomes. So the idea is, like we all believe in agile computing, so we also believe in agile impact assessment, and this is something that has to return whenever things change. Now, does that mean that we want fundamental rights by design? No, that's not possible. And I'm quoting this agency that says fundamental rights compliance cannot be automated and hard-coded into computer software. So some people think you can hard-code ethics into a system. I'm going to disappoint you. That's simply not possible. What you can do is to anticipate impact, anticipate potential violations, and to mitigate risks. And that's not only what you can do, it's also what you will have to do. What then could fundamental rights protection by design be? Think of very practically privacy and data protection, minimize, separate, abstract, hide, inform, control, enforce, and demonstrate. These are privacy strategies developed by Jaap Henk Hoekman. And there are, of course, lots of other techniques to diminish re-identifiability of data in training sets and sometimes also in the models derived from it. Think of differential privacy, federated learning, homomorphic encryption. And I also want to point out to one of the other fundamental rights that is very important here, that's equality and non-discrimination. In the famous presentation of Arvind Narayanan, where he, when the research into fair computing had gained steam, detected 21 different definitions of fairness in computing. He said in that paper, I've hyperlinked it so you can, I will upload the presentation so you can go to it if you don't already know it. We really need, next to privacy impact assessment, we need a prior bias assessment in, for instance, training data sets, etc. And I would also like to point to a book in the making by Solon Barokas, Hart, and the same Narayan, Fairness in ML, Limitations and Opportunities. This is the privacy design strategies, the little blue book by Jaap Henk Hoekman, where he explains the most interesting strategies to actually do what I would call data protection. So not just hiding data or something like that. That's just one strategy. Many times the issues are about linkability and different types of control. Here we have an example of the Danish Institute for Human Rights for a human rights impact assessment for artificial intelligence. Here you can see, I'm not going to go with you through all these, but one of the ways this could be done in a very practical setting. And this is the front page of Fairness in Machine Learning. And here, as an example, taken from that book, 4 types of NLP tasks and types of unfairness that could result. Perception, automated judgment, and predicting outcomes, and sequence prediction, different practical examples, sources of disparity, and what kind of harm this can bring about. This is the last slide. So this is a part of the book. And this is a part of chapter 11. That's the chapter where I discuss the relationship between ethics, code, and law, and emphasize how important it is to stay away from the idea that you can hard code the law or ethics into these systems, and emphasize how important it is to anticipate and mitigate, and how important it is then to stop sharing one's screen. Thank you.